If you're a landlord or a tenant in North Dakota, understanding its rental laws is essential to making sure you're being treated fairly. The state's laws are relatively straightforward, but there are some things to know before getting involved in a lease, or when bringing one to a close. We're eForms, the world's largest online database of fillable legal forms. In this video, we'll cover North Dakota's rental laws, including when to consult the law or the lease agreement, North Dakota provisions to look out for, and how the state approaches evictions. And if you're interested in having a lease agreement that meets North Dakota requirements and can be customized to your situation with step-by-step instructions, click the link at the end of this video. The first thing to consider with rental laws is, what is their relationship with the lease agreement? If you're a landlord or a tenant, odds are good that you signed a written lease agreement. And for many tenancies, this will be the only document you need. North Dakota law leaves many landlord-tenant matters unspoken, meaning that they can be decided on in the lease agreement. For example, the lease agreement will generally state when rent is due, and there is no state-mandated grace period. Even if something isn't mentioned in the rental laws, the lease agreement can be a good opportunity to address it. For example, there is no North Dakota statute about late rent fees. But if the landlord does want to charge a fee for delivering rent after the due date, it's generally a good idea to identify the fee in the lease agreement. So what are some specific provisions in the North Dakota rental laws to keep an eye on? North Dakota landlords must provide tenants with a property condition statement as soon as the tenant moves in. This is a description of the property at the time of move-in. It's similar to a move-in checklist that tenants can fill out, only here the landlord fills it out and gives it to the tenant. Landlords must explain to the tenant that they should inspect the property as soon as they move in, have the right to disagree with the descriptions in the statement, and that if the tenant fails to object, the statement can later be used to determine how much money can be retained from a security deposit. As for security deposits themselves, landlords are generally limited to charging no more than 1 month's rent as a security deposit, unless the tenant is a felon or has previously violated a rental agreement. If the tenant has a pet that is not a service animal or companion under fair housing laws, landlords may also charge an additional pet deposit of $2,500 or 2 months' rent, whichever is greater. North Dakota law also establishes the procedures for an eviction. Eviction is the process of removing a tenant for violating a lease agreement and, as in every other state, must be done through the court system. To start the process, landlords have to provide the tenant or tenants with a notice to quit, identifying a violation of the lease and stating that it must either be fixed within a set time period or the tenancy will be ended. In North Dakota, landlords are required to provide only 3 days' notice for all types of lease violations, including failure to pay rent. The landlord should arrange to have the notice officially served on the tenant and retain proof of service. Once this happens and the tenant fails to respond or fix the problem in time, then the landlord may file for an eviction in the district court where the property is located. A good understanding of state rental laws can help both landlords and tenants in North Dakota address potential issues before they turn into costly problems. To learn more about issues and other topics in property law, just click the subscribe button.